have an incredible episode for you guys today with Brian Bradley, who is an asset protection attorney.
Privacy does not equal protection. Privacy is just camouflage. When you're in a courtroom, privacy disappears. If you can't afford an LLC like $1,500 from a lawyer to draft up, then you probably should think twice before making that investment.
And we have so much valuable content for you guys in this episode. Brian, thank you so much for being here. Let's get started with the question that's on everyone's mind. Why do LLCs fail to protect real estate investors?
Yeah, let's just start off swinging, right? But thanks, Vince, for having me on. First of all, right, this is a necessary conversation, especially now, and we're in a moment in time where, the laws and legal regulations and landscapes are constantly shifting, and a lot of people are getting, half-truths and myths, and asset protection we'll define later on, but, it's a nice to have. It's, preparedness, like going out on a camping trip. And I think today I'm just going to, bust through a lot of the scare tactics, like we're going to start with LLCs and the misconceptions and actually talk about what actually works and what doesn't. And I'm going to try to do it through some case law.
Awesome.
Yeah. So LLCs, right? There's this big misconception and myth out there that an LLC is like a magic bullet, right? Like people act like it's the be all end all of protection, but they miss like the first word, right? Limited. They tell us this straight up in their name. They're not hiding it. They've never been hiding it. Now, I don't want people, first of all, to think I'm anti-LLC. I'm not. I use them all day long in every single structure that I create. The problem isn't the LLC itself. It's how people use them. So think of an LLC like your base layer of clothing on a freezing, stormy winter day. That thin shirt that sits on your skin under your body armor. It's necessary, absolutely. Is it sufficient? It's not even close. So if you think one LLC is going to stop $1 million lawsuit, then you're going to be walking into a blizzard in a t-shirt. So courts pierce sloppy LLCs every day. So we need to talk about the reality of LLCs, and I really want to focus on the Wyoming LLC. It's the state that everybody loves to name drop because of no income tax, anonymous ownership, strong exclusive charging order laws. It all sounds great, and it is great for privacy, but privacy is not the same thing as protection. And I want to say it a different way. Privacy does not equal protection. Privacy is just camouflage. It hides you from the public records and nuisance lawsuits. But once you're in court, once you're in a courtroom, privacy disappears. Courts can subpoena your bank accounts, your title company, your property manager. We can find out exactly what you own in minutes. And people think that if they can just, hide or, hide behind a registered agent or hide behind a service company or hide behind a nominee, that they can't be reached, that they can essentially just like ghost a lawsuit after a bad first date. And that's just completely wrong. Those are just forwarding mailboxes. They exist to receive the service of process, not to block you. So once they receive it, it's forwarded on. Congratulations, you've just been served. Now you got to show up into court. So when someone files a lawsuit, that agent is legally required to accept service on your behalf and then forward it to you. The lawsuit starts. And here's where things get even more real. Promoters and salesmen, they're going to sell you something like form in Wyoming and just you're protected everywhere in every state, no matter where you're at. That's not true. That's not the case. Once you're in court in California or New York, Florida, Texas, Illinois, like the big states, guess what? That court applies its own laws, not Wyoming law. And this was hammered home in Mallory versus Norfolk. If your company is registered to do business in a state that, and you're not it's not a part of that state, the jurisdiction is going to be the state that you're actually registered to do business in. So you can't just go and buy a state's more beneficial laws and bring them to a state that you have no connection to. It doesn't work that way. And so what we're doing here is mixing business law and tort law. So if someone, for example, trips on your property and cracks their skull open, that's tort law, right? That's damage law. That's not business disputes. That's not a contract dispute. So if you have a mold or a lead poisoning issue in your rental property and a family member gets sick and they sue you, that is a personal damage tort claim, not an internal affairs of business dispute claim. So state laws apply to personal injury lawsuits. No operating agreement is going to save you from negligence. And the receipts on this are really clear. So for example, there's Kersey versus Baldwin in California. Olmstead versus FTC in Florida. New York use internal affairs doctrines. Texas courts apply their own enforcement rules. So the takeaway for LLCs is that it's your first base. They hold the assets. It's asset protection 101. It's not the armor yet. The real armor are asset protection trusts and how we layer out and scale the system. We just have to understand what the starting point of an LLC actually is.
So it sounds like people are kind of thinking about it incorrectly, and they may just be going off of what they hear of. I heard that Wyoming is maybe a place where I should open my LLC because of privacy laws or some of the other things that you mentioned, but it fails to consider the real practical parts of it that are actually important as far as how things would play out based on the state that you actually have a connection to. So should people be thinking about creating an LLC where they live, or how should they approach how they're going to set it up in the first place? Because I think that most people are probably just thinking, I'm going to go on LegalZoom and open a basic LLC for my first investment property. And we're going to go through the tiers of investors and what levels they're at and what kind of considerations are involved for those different tiers. But how should people be thinking about this as they approach it at the base level?
Absolutely. At the base level, LLC should be formed at the state where the asset is located at. So if you purchased a rental property in Tennessee, it's a Tennessee LLC, Florida LLC. And that's just because that's where the liability is going to come, right? The contractor slips and falls off the roof, you're going to get sued in Florida if it's a Florida property. Wherever the injury happens, that's where jurisdiction legally happens. Where's the property at? Where the injury happened? Where's the plaintiff at? That establishes jurisdiction. And then, like I was saying, is if Vince and you and I were to go and create a business, and we're going to say, let's just go sell widgets nationally. You and I can go and create a widget selling company and use like Wyoming or Delaware or Nevada to incorporate. That's pretty standard, right? Because this is a business. We're doing it nationally, and it's really for the internal affairs and disputes of the business. The business is winding down. Vince and I are suing each other. We want our operating agreements to have credence from that aspect, from the business or contract aspect. Real estate's different. You're not using LLCs as a business operating company. You're using it as a holding company, which is essentially an extension of you. It's just creating a very thin first layer of protection. Get the property out of your name. Put it in something that's going to hold it. Then we layer it out. Like we can break down the layers, afterwards. But once you get the LLC to hold the asset, then we add management companies and trust. And so that's where we're at, is create the LLC in the state where it's located at.
And when should people be thinking about putting their properties in their personal name versus getting an LLC? Because we're going to go into deeper and more advanced topics today, but I do want to make sure that we cover that one because it's probably the most common question that I've been asked across the thousands of conversations I've had is, I'm buying my first investment property. Do I open an LLC and put the property in there? And aren't there considerations too, perhaps maybe there's a higher tax rate, maybe the insurance is higher, maybe those companies don't like it being in an LLC because owners are trying to shirk some of the responsibility. And I've even seen in my own experience, a lot of investors who will buy a portfolio of properties and they'll put each individual property in its own LLC, which seems like it would be an operational headache and nightmare. What are your thoughts on these things?
Yeah, so there's a lot to unravel there. And so when you're closing on the property, generally you're going to close in your personal name, especially if you're new to investing. Not many banks and lenders are going to say, all right, we're going to give you a line of credit or trust your business, your LLC that's just created yesterday to close in. So the likelihood of actually being able to close in the LLC is unlikely. You'll get a better rate generally closing in your personal name. So rule of thumb generally is we have over 3,000 clients, over $6 billion worth of real estate that we're protecting for clients. Almost all of our clients close in their personal name and then transfer title after it closes into the LLC. And so that's how it goes. You'll get better rates. If you're established and you've been around for a while and you have a good relationship with your lender, sometimes then they'll be fine with closing in the LLC. In the realms of what was like one of the 6 questions piggybacked off of that one.
If they should be getting an LLC for each property, or if one LLC should have their entire rental portfolio, because I do see that sometimes, and I can't imagine the paperwork that they have to deal with at the end of the year.
So correct, and there's ways to clean that up. So the best way to do it from a legal standpoint is one for one property per one LLC, right? Like separate all your eggs into their own basket. The general rule of thumb, though, is you can get a little bit of a stretch out of an LLC, depending on the state and the type of property that it is. So what that means is We generally say like 500,000, 600,000 max of equity per LLC, or no more than like 4 units, 4 doors. And that way we get a little bit of stretch, we get a little bit of more use out of it. It's not as insane as saying let's put 10 properties all in one LLC, because then if one asset explodes, we call like a lawsuit an exploding asset, everything in the bucket is now tainted, right? So we want to separate out risk as much as possible. Some exceptions to this: commercial property should always go into its own LLC. It's just more risky. Multiplexes, like 4plexes or larger, should always go into their own LLC. If it's low equity, let's say you have 4 single family residences and they're all in low equity areas and the equity is below 500,000, put them in one LLC. And then if you get another batch, put them in their own. So when we're looking at it, we're really looking at what's the total equity, what's the character of the property, and what's the risk level of it. And then we kind of make the tactical decision from there.
If you spend enough time in real estate, you start realizing that some of the most useful lessons don't come from books or podcasts. They come from conversations with other investors, talking through deals, mistakes, and decisions that you only face once you're on the journey. The Launch REI Newsletter is where we share those insights, the takeaways from our podcast guests, lessons from inside our mastermind community, deal breakdowns, and the patterns that we're seeing as investors grow. It's free, quick to read, and built to help you make better decisions as you scale. You can subscribe at the link in the show notes. Okay, got it. Let's go into the tiers of investors and what kind of considerations they need to be thinking about at these different levels. So for your first tier, it's going to be people that are on their first rental property. They're an early investor. What types of considerations do they need to keep in mind? What would be smart for them, operationally sound, reasonable protection? They don't want to be reckless. So if you're sitting down grabbing coffee with someone that's in the early stage there, what types of things would you think about recommending to them?
One, I would say don't consider investing unless you're ready to do the formation aspects of it. That's what people generally starting out skip, right? I'll get insurance and I'll skip the LLCs and the operational formations and the CPAs and all of that until later on when I get in trouble or I grow more. The problem is when you're new, you don't know what you don't know, and that's probably like your highest level of getting sued, because you're doing a lot of things wrong. And then the next level is when you make it and you're really doing a lot bigger deals or you're sponsoring, then you're increasing your big red button of you and liability even more because the deals are bigger. So when you're just starting out, the worst thing to do is just say, I'll create the LLC and everything later on. That's if you can't afford, an LLC like $1,500 from a lawyer to draft up a good LLC and operating agreement for you, then you probably should think twice before making that investment because you're probably not ready yet for it. So that would be my biggest one there. To go off of like when we're talking about like a lot of LLCs adding up, that's where management companies come in. So like I have clients that have hundreds of LLCs. At the end of the day, they're just disregarded into the management company. So all the K1s and tax returns flow up and into a management company. So it cleans you up from a tax-wise. So it's just generally one tax filing through the management company.
That made things so much easier from a scalability perspective. And that's something that's really important is investors tend to be very clumped up in the earlier stages where 90% of investors have maybe just one rental property or just a small handful. So those investors that separate themselves from the pack and they get past 10 and maybe they're getting to 20, 30, they're starting to get into small multifamily or something similar. They may not have peers around them. They might not have the best tax and legal advice. And so as we start to get into that tier where they're separating themselves a little bit, what kind of considerations do they need to be thinking about in terms of asset protection at that stage? Maybe they've got 10 single family homes, or maybe they've got 3 or 4 and then they've bought their first small multifamily. Maybe it's 20 or 30 units. How should they be looking at asset protection at this stage?
Yeah, so I think the best way to break this down is think about asset protection through layers in winter. I think I like to use this analogy the best because it hits all different stages. So we just sort of talked about when we're just starting out, right? That's your entry layer, your first level. That's your kind of merino wool sweatshirt layer, or really that what we're talking about. The second layer is the merino wool sweatshirt, but the first level, the entry layer, that's like our base skin layer, right? That sits on our skin. We're just starting out. We kind of went over that. That's LLC and insurance. Then you hit to where you're talking about maybe you have 500,000, 700,000 of equity, you got multiple LLCs, you got multiple real estate rental properties. That's when management companies come into play, right? And what it does is the management company helps consolidate LLCs into one place where all of those K1s file up and flow into one management company. So it's just one tax filing at the end of the day. And then that's where your true protection really starts coming into play. Is that's where we can start picking better jurisdictions, because it's not a holding company. It's an actual business that's managing assets. So that's when we can start looking at, Arizona, Wyoming, Nevada. We use Arizona because we use an Arizona limited partnership, and I can explain that later on why. But at that second layer, the mid layer that you're talking about, is where management companies start coming in. And then it helps consolidate you from a financial perspective, because then you can add, bank accounts into there and QuickBooks and start managing the money and coming in and out better. You can start holding different assets, because a lot of this isn't just about real estate. You also have stocks, bonds, right? Intellectual property. Maybe they have other businesses that they created. So there's other things and assets and investments that they have to consider to protect as well. This isn't just, we need to protect the real estate. There's your primary home. Where does that go?
Got it. Okay. And there are a few people that end up making it to the very top of the totem pole, and they end up as significant operators. They start creating syndications. They're doing deals that have hundreds of units. At this stage, I'm sure it changes entirely, and they start to have more of a budget for legal protection, and they could be thinking a lot more strategically about the type of services that you offer and making sure that they're protected personally as much as possible when they're operating on such a large scale. So as people are starting to approach that $100-200 million worth of commercial real estate, what kind of relationship are they having with asset protection, and at what level are they engaging with you? And, does this start to become a very frequent conversation around strategy? And, does there become some kind of default structure, or is everything very complicated and customized because each person's portfolio and business is going to be very different, especially if they're in different regions and states?
Yeah. So the general structure typically stays the same, because you're using limited liability companies, a management company, which would generally either be a limited partnership or an LLC, and then on top of that would be an asset protection trust. Where you fall in that scale depends on the client profile. Like, what is their day job? Are they doctors, surgeons, lawyers, CPAs? Are they real estate investors, 100%? Where's the risk come from? And then it's a matter of how much equity is exposed, right? So for example, let's say I buy my rental property and I have no equity in it. I just purchased it. I barely have 20%. It's a $100,000 property. I put 20% down. I have $20,000 of equity. Well, if you get sued, there's not much there, right? So the debt actually helps you from an asset protection standpoint, because you're not really worth anything. Now let's just say you have $1 million property and it's owned in full. Right. Well, there's $1 million worth of equity there that someone can sue you from. So the situation changes a lot. So when we look at it, really, when you get to that higher echelon, the number that you meant, like 100 million, 200 million, it really comes down to, once you get to about $1.5 million of exposed equity and you have sort of like a high risk job, that's when you use the whole setup with LLCs, management companies, and asset protection trust. Because it generally takes people a long time to get to that number, and then one lawsuit can easily clean all that out. And so asset protection trusts come into play as that kind of like outer shell waterproof layer. It's your break glass in case of emergency layer, that firewall protection layer. And that's when that comes into play, is when you start having 4 or more rental properties, you're investing in different states and have different LLCs, and you have higher risk because of your profession, or if you're just 100% real estate investor, that's when these layers come in. So I think we need to look at it as, you should be having these conversations not when you hit $100 million value of real estate. You should be having these conversations with your asset protection attorney and your CPA from the first time you decide to buy your first property. Then the systems just scale and grow as you do, right? Then we're just picking the right tools, and you can't be short-sighted. Like, part of the question should be, what's your short-term goal? What's your goal in the next couple of years? Where do you want to be in 10 years from now? Because then we have to pick and choose the right tools from that standpoint. So if I only want to buy this one rental property, this is all I want to have. Get an LLC and insurance, we're fine. If the goal is I want to have 10 rental properties, I want to be living off of cash flow, I want to quit my job as a doctor and just like live off of the real estate, then we're going to probably be looking at LLCs, management companies, and a hybrid trust, because we got to protect a lot more. But if you're already starting out with 2 properties, I got to know where we're going, because I have to be able to put the proper pieces of the puzzle in place and know how we're going to scale this.
People that are investing in real estate are tending to skew a little bit older, as there's been affordability challenges lately. And just a reality of life is a lot of people are in relationships. A lot of people are married. A lot of people got married maybe without a prenup or before they even knew that they were going to start investing real estate. So one of the questions that everyone always wants to know is, if people get divorced and they've been investing in real estate, who gets the house?
Yeah. So that's going to depend on your state at the end of the day. Like almost every state's a community property state or 50-50, equal ownership state. So the biggest misconception, besides I'll just do this after I get sued, we explained that afterwards, is I want to create asset protection because I'm going to get in a divorce and I want to hide my assets so my ex doesn't take my stuff. You can't do that. It's not asset protection. That's literally the definition of a fraudulent transfer. And the reason is that your spouse is not a creditor. And I'm going to say that again, like long dramatic pause. Your spouse is not a creditor. They are co-owners of the assets with you. And what you need to realize is divorce court is different. Divorce court, you go into court and a judge will say, go to mediation. You two work out who gets what, or I will order who gets what. And there's no coming back from that. And so I can't create, like we do high-end asset protection, offshore Cook Island trust, like the strongest stuff that you can do. Even if I were to take the Cook Island trust and stuff all of your assets into an offshore, purely Cook Island trust so that your spouse cannot get access to it, it will not work. And you can call the Cook Island trustees in the Cook Islands because they have their own laws and their own constitution, their own licensorship that they're going to maintain. And they'll say, no, that's the direct definition of fraud. It's a divorce. Your wife is not a creditor. Your husband is not a creditor. They're co-owners of that property. What's the court order say on that? It's different if Vince is suing me and he wants to take my assets and we have no relationship with each other. He's a third-party creditor trying to take my assets. That's where asset protection comes in. And so when it comes to getting married, buying assets, get a prenup. And it's not a bad thing. I forget who I heard it from explaining it, but it really helps with managing finances, and then you separate out your own accounts, and it really makes buying personal gifts really special, because now I save this money away from our community assets to buy you this specific gift from me. And it makes it a little bit easier to manage. You get some credence if you do get divorced down the line, because then I can match the language of the prenup into the asset protection plan. And then everything you build then community-wise will then be split, but there's more tools that we can have to protect the assets. So it's all about pre-planning. Like we go back to, we didn't talk about it, like what is asset protection, but it only works beforehand. And so the more pre-planning you do, just like in life, like talking to your CPA, the better off you're going to be. If you try to do any of this stuff, or you try to, manage your finances afterward you get the letter from the IRS, you've messed up a long time beforehand.
I think that so many people are curious about how all of that works. And so just having that insight is really valuable. And I appreciate you kind of shining some light on all the considerations and the pieces that are involved in that whole process. And it's obviously very personal. It's one of the most challenging things that people could ever go through. And I've heard many times that everyone has a prenup by default. It's the one that you get from the state that you live in. So you can either take that one, which generally isn't very good, or you can have one that's customized and designed. Do you agree with that?
Yeah, and that's a great line. Like my line, I always like to use, you don't rise to the level of your income, you fall to the level of your legal structure when things go wrong. And so I completely agree with you 100%. Like, what's the pre-planning that you're doing? And it goes to kind of like the definition of asset protection. I know we haven't defined it yet, but I think this ties in exactly into what you're talking about, because asset protection is literally just creating a legal barrier between you and your assets before the problem happens, right? Before the lawsuit. That's it. It's not secrecy. It's not about hiding or evading taxes because that's illegal. It's about legal structures, not concealment. So think of it like a safe or a firewall. We're putting, our gems, our gold, our jewelry, watches, guns behind safes, right? We're not putting them on the front porch where they can easily be taken. The same thing applies with our assets. And so asset protection does the same thing for our investments and our rental properties, our stocks, our bonds, our personal residence, our cash, your businesses, by moving them out of your personal name and then behind the different legal structures that we're using. And when it's done correctly, it's tax neutral. But the two biggest concepts, kind of like what we're hinting on and where this ties into that topic, is timing and control. And I can break that down real quick for a great case, if you don't mind.
Yeah, sure. Let's go.
Yeah. So timing matters in all aspects of life, but timing 100% matters when it comes to asset protection. And so there's this 2010 case, SEC versus Solo. Now, Mr. Solo got nailed by the SEC for a fraudulent trading scheme. And after they hit him with the massive judgment, he moved assets into his wife's offshore trust, thinking that it would protect them. That's just the classic post-judgment after the fact lawsuit transfer. And the court saw completely through it. So he was held in civil contempt of court, and he straight up should have been, right? But here's the twist here where most people miss this. The offshore trust still worked. The SEC couldn't touch the assets. And so we have two big lessons that come from the Solo case. One is that offshore trusts are incredibly powerful when they're structured correctly. But two, and most importantly, is that timing is everything. You see, Mr. Solo didn't get in trouble because of the trust. He got in trouble because he acted after the judgment. He transferred assets after the fact. That's like trying to go and buy car insurance after the car accident. It doesn't work that way. So the takeaway isn't don't protect. The real lesson is you have to plan before the lawsuit hits. So the takeaway is protect early and just be honest.
Got it. Yeah, I appreciate you sharing all of that because that is the kind of detail that I think a lot of people would be looking for if they're wanting to get a deeper understanding of how that actually works.
I get that question all the time. Yeah, no, I mean, but I really want people to trust that point because of I listened to you on so-and-so. I watched you talk at this and I'm getting sued. What can you do for me? I'm like, we need to go back and backtrack up and work on listening comprehension skills because I literally said that's a fraudulent transfer. You're currently getting sued. So I think people really need to dial in. If you're going to create asset protection, it has to be done when you're not under attack. And the real definition isn't am I currently getting sued? It's foreseeability. Meaning if you hit somebody with your car, you're not going to get sued tomorrow. You will get sued generally when I did my plaintiff's work because I have a trial attorney before I did asset protection. You wait to the very end of the statute of limitations before it runs because you want to see how bad things are going to get the max amount of damages. So let's say a year or two goes by, you see a deal that you want to go and buy, and then you go buy that deal. And then you get sued a year or two later, right before the statute of limitations runs. They're going to say, well, Vince, you knew it was foreseeable that when you hit somebody with your car, you're going to get sued. And so what you did was change the character of that assets, like that cash in your bank account, to hide it in real estate, undo what you did and give them access to that money. And that's what happens. So the problem is human nature. Human nature, we don't do things until we feel the pinch. And the pinch has to be we feel the pain, right? Like we don't create estate plans until we're on the deathbed. But then if it's a quick death, great grandpa didn't have an estate plan. He was going to get to it later on. Now the family's, going down a creek without a paddle. Same thing with asset protection. I'll kick the can down the road. Next deal. Oh, lawsuit. What can you do for me, Brian? I can't do anything for you now.
It's so true. People tend to be very reactive instead of proactive. And I think that asset protection is something that is exceptionally easy for people to kick it down the road. Maybe they don't want to spend the money on it. They look at it as an expense and it might not make money. But what is it? The first rule that Warren Buffett has is don't lose money. And the second rule is don't forget rule number one. And probably one of the fastest and easiest ways to lose the most amount of money is through a lawsuit and not having your assets protected.
No, I agree with that 100%. And like I said, it's just a matter of delay. I talk about this when I talk to clients is the unspoken risk here is the risk of delay and kicking that can down the road. Because if you delay, people think I have the same options on the table as I did yesterday. It's a different day. right? This lawsuit comes, your options are off the table now. And so you need to do this just like you and I have a kingdom and we have a castle. I can't build the castle and fortify it while I'm being sieged, right? We have to do it before the fight starts. Afterwards, it's too late.
That's a really good visual, and I think that's a really good way for people to think about it. And I like the car insurance reference too. Like, after you get hit is not the time to be thinking about getting car insurance. So I think those are some really good metaphors and analogies that people can really think about. Can we briefly touch on personal liability versus asset liability? Do you have any thoughts on that topic, and what does that kind of look like? What should investors be thinking about?
Yeah, I think like we look at it through the eyes of like inside liability versus outside liability, which just means inside the LLC, the real estate, rental properties inside the LLC. Someone gets hurt, it's inside the corporate structure, right? And then it's a matter of I hit somebody with my car. That's outside liability. That's personal liability, right? So the key to asset protection is protect from both. Someone getting hurt inside the property, inside the LLC. And you doing something negligently in your life, like plowing somebody over with your car, and I'm still protected. The way you accomplish it is the same way, is get the assets out of your personal name and behind the legal structures, right? So rental properties and LLCs, separate out buckets, so then we're separating out risk, and then get the primary residence out of your name, the stocks out of your name, put them into management companies and the trust. And from there, you're separating, you're protecting yourself from all the liability inside and outside. The name of the game is, what is the rule of like the rich own nothing, benefit from everything? That's exactly what the game plan is get everything out of your personal name and into the right bucket.
One question on that topic: when can creditors go beyond one property or one asset and go after more, or go after you personally? Do you have any insights on what that could look like?
Yeah, they got to pierce the veil, right? That's why we're putting all of these property. I like, it's a real estate, people are investing in real estate. So we want to put like rental properties in LLCs. And then when something goes, and when we separate them out so that the risk is not contained into one, we separate out the risk into different buckets, because if we call it an exploding asset, not because like the property actually explodes, it's just what we call a lawsuit. And so something happens on a property, it's an exploding asset, that LLC is now tainted. And so what they're going to try to do, especially if it's a big lawsuit and it can be worth like millions of dollars, is, well, Vince has a lot of real estate and spaced out through all these LLCs and management companies, and we want to collect on that $100 million of his to get a max judgment on it. We got to pierce through this LLC that contains this asset. And so that's what they do, is look at, all right, how is that LLC? Is it mismanaged? Is it a shell for yourself? Meaning it's really not a business. It's a holding company that's an extension of you. Were the formalities done properly? Was it properly funded? Are you commingling assets? I mean, there's a endless list of ways to pierce corporate veils. I think almost any attorney just out of law school that passed a bar exam can pierce the veil of an LLC. It's pretty simple, because no one's perfect with money. No one's perfect at managing and not commingling assets. Generally, a formality is missed, especially if you're DIYing your LLC and not having it, properly funded and drafted. And most of the time, like, funding issues are what go down. What happens, like underfunding an LLC, not capitalizing it. And so this is kind of the way that goes, is just, I need to get into the rest of the assets. Let me pierce the veil. That's why the rest of the layers come into play. And then each layer is stronger and stronger, right? So like the management company is in a stronger jurisdiction because now it's a business. So we can break down why for that. Then let's say then the limited partnership gets pierced. The trust, okay, what type of trust are we using, right? And so each layer, just like our defense of our castle, the strongest fort out, from your castle is not your strongest defense layer. But each defense layer coming closer and closer to the castle is a stronger and stronger death trap, right? And so it's the same thing with the asset protection system. And so that's how we go about that.
I like that analogy, and I think it makes a lot of sense where, you're thinking about it in terms of layers and walls and if something can be pierced or not. And I think it helps to kind of give that picture to people. And I'm also realizing, as we kind of talk through this, that I think most investors are woefully inadequately educated on this whole entire topic, and that, there's probably a lot of detail that investors simply can't know because they are not asset protection attorneys, and that's why you engage outside counsel. But is there some kind of baseline 101 of whether it's 5 or 10 principles or a book or even some blog posts? Is there some basic fundamental content that most investors should consume or understand just to know any core principles or rules, or does it not really work that way?
There should be. And this is the issue with asset protection is I wrote the book on it because no one wrote the book on it. Like, you can talk to an attorney and you'll get different advice from all over the place. And most attorneys are not asset protection attorneys. They're generally, I'm an estate planner. I'm a real estate attorney. I do trial work. I do DUIs. And then in the civil world, like, a lot of people just, if you're a solo attorney, don't want to pass up work. But they're not in their specialty. They're not in their lane. And there's not the overall horn book on asset protection. You're not taught this in law school. It's not on the bar exam. And so you generally, like in any business, you learn what your firm that you started with does. And most people don't just do this specifically. And most of the firms that do try to do it, they do it. I equate it to like insurance, to where you're not going to be representing the clients like I do, like the big sharks, right? Because they're few in between, but there's a lot more little fish out there. Well, what do little fish need? LLCs and a management company. And kind of the knowledge stops there because they can cast the widest net nationally with just get an LLC and a trust, like an estate plan, and get some insurance. And that's where most people fall. But then when you get more risk, more assets, you need a lot more protection because those LLCs can be easily pierced. And so, but that is not the easiest way for like an insurance company, if we're going to keep on that analogy, to make the most money. So these firms need to cast larger nets. Larger nets are just LLCs. And so there is a lot of misconceptions out there is because people are just trying to pitch their product of their business and not doing what lawyers do, is not to pitch the product. It's to evaluate the client's need, educate them on the law, and then provide pros and cons of options, and then let them decide what they want to do. But you're getting businesses that are disguising themselves as pretend law firms, but they're legal solution providers, not law firms, selling products and then giving you legal recommendations, but then telling you, well, but we're not lawyers, and is creating this massive misconception and misunderstanding of what's going on out there with a small number of attorneys that actually do this. And so that's why I ended up writing my book, because I'm like, people are asking, where's the horn book? Where can I get this information? And I'm like, it's a great question. And when I did a deep dive in it, there was not one at all. And so I just wrote the overall arcing. Here's asset protection from the very bottom level, LLCs, insurance, management companies, trust, different types of trust, pros and cons of all of them. So people at least have a base layer foundation to where if they read that horn book, then they can ask the proper questions and not be sold a line of BS.
That's great. And if people want to find out more information, where would they find that book?
Yeah, you can get the book on Amazon. It's called Overexposed. And then for people who call in for consultations, I generally just send you like a digital copy of it.
Real estate is a team sport. You can grow so much faster if you're in the right room. The Launch REI Mastermind is a curated space for investors who want to move from hands-on execution to professional portfolio management. This is your personal board of directors. Inside, our conversations go beyond the tactics. We cover the decisions that actually change outcomes, structure, tax strategy, and capital allocation. If you want to build alongside a vetted peer network designed for the long term, apply for the Launch REI Mastermind at the link in the show notes. Let's move on to talking about the different types of real estate businesses that people might have or portfolios. And we'll keep this one a little bit high level. We might only spend 1 minute on each of these, but there's kind of these big general categories. If people are acquiring a portfolio of long-term rentals, versus if they have a more active real estate business, whether it's wholesaling or flipping, they kind of have a team that's actively involved. And then there's another category where you're kind of really scaling, whether it's mobile home parks, self-storage, multifamily, you're doing hundreds of units kind of at scale. As you kind of look at these different types of real estate businesses and portfolios, how should investors be thinking about asset protection depending on which one of these they fall into? And even Airbnbs is a common one where they could easily be overlooking this, which might be one of the most dangerous ones at all because you have so many guests that are coming through and there's so many things that can happen.
Yeah, absolutely. So I think because you ended with that one, Airbnb, short-term rentals, high risk. I mean, just be honest. Like you go to an Airbnb, you're on vacation. Most people are drinking. staying up late, something bad happens. I think it was Louisiana. This case a couple of years ago where a guy was at a short-term rental just plowing down bottles of whiskey and then ran out the back door, did a head dive in a shallow pond in the property, broke his neck, became a paraplegic, and then sued the owner of the property and got I think it was like a $15 million judgment against him for negligence because they had a shallow pond on the back property, and he pounded a bottle of, I think it was like Jack Daniels, and was a dumb drunk running out the backyard at 2 a.m. in the morning doing a head dive in the shallow pond. And so,
oh my God, I can't even believe that can happen.
No, I mean, and I see like the classic, because we're, people are watching, like your mouth wide open, in shock of the story. But I mean, this is what you're dealing with nowadays. So when you're doing short-term rentals, Airbnbs, it has to be in an LLC to start, get it out of your name. And then it comes down to just like, what's the nature of the property? Is it on water? Is there a pond on it? Look around your property. Know what are ways people can get hurt here. Is this a high risk property? It needs to be in its own LLC. Is it not? Okay, then maybe we can clump it up. From there, then it's what's the character of the asset and the property? Like I was saying, is it commercial? Own LLC. Is it single family residences, long terms? We can clump those up. So this is how we do the evaluation, is just identify the character of the property. Let's talk about its use. Let's talk about damages that are around it. Like, is it on a lake? Is it on the ocean? Do you have boats on it? Like, are people going to be able to take a boat or a canoe on the water and potentially flip over and drown? I mean, these are all the things that have to be considered.
What's the quote? Anything that can go wrong will go wrong. So from a legal and protection standpoint, it's really important to think about these things. And I'm glad that I brought up the Airbnb one, because that does seem like one of the really common ones. And there's so many. There's got to be millions of Airbnb units. So I'm sure that things like this happen all the time.
I'll add on to that and say, well, I think that Airbnb, they give us insurance through it. That's not an asset protection strategy. One, it's for their interests, not yours. Two, what's the claim limit? What's the wiggle room out of? All insurance has, okay, we're not going to protect for gross negligence, intentional wrongdoings. So you got to understand what is the out of this as well. And all insurance does is provide capital to fight. That gets eaten up in lawsuits. And then most of the time they'll now deny the coverage and the claim. And now you have to sue the insurance provider while being sued. And you're fighting two different lawsuits now. And you're the one that's left with the judgment at the end of the day.
Got it. There's been some conversations that I've heard before where people have heard some crazy stories about accidental fraud as they're going down their real estate investing journey just because they didn't know what they don't know. And what are your thoughts on some key aspects of that people really need to be aware of? Where can that happen? Where do you see people falling into those types of pitfalls?
Yeah, I think you got to, general negligence is kind of what you're looking at. Is you can get sued from anything. There's a crack that's on the driveway, and then the person trips and falls, and you're aware there's a crack on your property, and if you're not aware of it, you have a general liability duty as a business owner to inspect your property like in a reasonable amount of time and take those negligence, damaged areas away. And so this is what people need to realize is it's really easy to get sued. And once that happens, there's nothing that we can do about it. And so part of asset protection is cutting out the, what is it word I'm looking for? The financial aspect of trying to pursue you for money. And a lot of the lawsuits aren't always these massive catastrophic, we're going to lose everything. A lot of it is just quick money grabs. You want to evict somebody and get them out of your property because they're not paying your rent or they're causing damage to the property. And if you're in California, Oregon, Washington, New York, and these areas, good luck. And then they're going to sue you because you're discriminating against them or you're harassing them. And then it's just going to be this drawn out process, and they're just trying to settle for a quick 40, 50,000. And so this is just another aspect that if you're going to own rental properties, you need to realize this is the game that's going to be getting played, and you got to have to protect yourself from this.
Can you talk a little bit about trusts and more advanced structures? Because I think that's something that people begin to think more about as they get further down the road in real estate investing. And it's a conversation that just doesn't come up all that often. So it may be valuable to touch on it so that people can at least have a baseline understanding of what that looks like and when they should be thinking about it.
Yeah, so this is a really big misconception. So I might ramble for a few minutes on this one just because I think there's a lot that needs to get cleared up here. And so we talked about like the foundational piece, LLCs, right? And then we talked about a second layer, management companies. So the outer armor are asset protection trusts. So think of it the equivalent of like a ballistic shield, all right? It's the heart and soul of a complete asset protection system. And so this is where we stop playing defense and we start building our legal fortress. And so these are asset protection trusts. But not all trusts are created equal. One problem is that people tend to lump all trusts together. Like even well-meaning estate planning attorneys do this. They think, I have a trust, I'm good. A trust is a trust is a trust. And, they also, a greater way to think about this is, I have a car, so it has to be an F1 race car. Or they create two mental shortcut categories. One is the revocable living trust. The other is self-settled, offshore, and immediately the brain defaults to bad because they're just not educated and don't know any better. But trusts are like the ice cream store Baskin Robbins, like lots of flavors. And so most are not built for asset protection, and each state has its own laws. And then we also have federal laws to consider. And so just to get a concept of a few of the common types, we have revocable living trust. They're great for probate, avoiding, probate, naming beneficiaries, but they have zero lawsuit protection. And these are for after death planning. Then we have land trusts. They're good for privacy and real estate, but no liability shield. So if the LLC that it's tied to gets pierced, the land trust collapses. It's worthless. Then we have tax trusts like Delaware Trust, generational wealth skipping trusts, spousal trusts are really popular in New York. So those are all great for taxes, completely useless for lawsuits. And then we get into asset protection trusts. And now we're talking about power. And so a proper asset protection trust is self-settled, it's irrevocable, and it has spendthrift provisions. And so self-settled means it's created for you, by you as your own beneficiary. So it's a very unique type of trust. Not all states recognize that. I'll talk about that in a second. They're irrevocable, meaning that its terms are fixed. It doesn't mean you can't move assets in and out. It just means that its terms are fixed and a judge can't force you to change them or like revoke them like an estate plan does. And then spendthrift provisions. That's just like the teeth that keeps creditors out. But as you can see, each type of trust has its own purpose, just like a hammer, a screwdriver, and a wrench. We have to use them for the right reason. Otherwise, they just don't work. Just like I can take a hammer, right, and try to hammer in a screw, but it's probably just not going to work really well. So when it comes to protecting assets, purely U.S. domestic-based asset protection trusts, sadly, they just fail. Judges pierce them constantly. Judges ignore choice of law clauses and they apply their own state's public policy, just like we talked about with LLCs. And that's just a judge's superpower. It's the magic wand of public policy. And we got real world failures. That's In re Hubbard, Bately versus Mortensen, Dell versus Dale. And in big liability cities like California, New York, Illinois, Florida, and Texas. Yeah, I named Florida and Texas there. They don't even recognize self-settled trust at all. So we got in California, it's the Kilker versus Steelman. Florida, it's Monette versus Brown. Texas is In re Blount. And so under the full faith and credit clause of the Constitution, a judgment in one state has to be honored by all other states. You can't just run away from a judgment. So that's the foundation of our legal system. So as we can see, there's a lot of confusion and misconception that starts to add up. And so people start asking like, all right, this seems then like a complete mess. Like, what's the solution then for this? So that's where hybrid trust comes into this. This kind of fixes this problem. The strength of like an offshore Cook Island trust is that it refuses to recognize any foreign judgments in the world, including the US, for the last 40 years. It's the strongest thing in the world that you can create to protect your assets. But it's generally just way overkill for most people. They're expensive. They have mandatory IRS disclosures. You have to be out of control of the trust. And they're just, the cost is unreasonable for 99% of society. With the domestic side, even though they fail most of the time, they're very simple to use. Domestic IRS favor, the IRS favor domestic trusts because you don't have to do any of these tax disclosures. Like there's no 2530s, 2538s. So think of a hybrid trust like a hybrid car. You get full offshore power when you need it, with domestic tax simplicity and control over your assets. And then you have the DNA of the trust ingrained with over 30 years of federal case law on the Cook Island Trust. So it's really like having a Super Mario Brother power-up in your back pocket, just ready to deploy when the legal system turns on you. But it's this hybrid of the two structures together that actually give you the best option. Each one separately, one's just way overkill, and the other one is simple to use, but it just sadly doesn't work. And no one wants to create a false sense of security. Like, it's cheaper, but just because I pay for something that's cheap and it doesn't work when I'm getting sued, what was the point of creating it?
There's so much knowledge to unpack in everything that you just said, and so many just years of expertise. It's unbelievable. So whenever I have questions on those things, I will certainly know who to call. It's really remarkable, just the amount of knowledge that you've gained on all of these things. And obviously you went to law school, but you could tell that there's, decades of just experience and practice. And I can't even imagine how many books you've read to be able to just gain all this knowledge. So I appreciate you just being able to share all of that with us. Let's talk about freezing assets. When can that happen to someone? And is that something that people should be worried about?
Yeah, so that's a great question. And it's kind of like the last misconception I think that really needs to be busted. And it makes the most sense when we talk about it through fraudulent transfers. And I want to explain it through two cases, because in these cases, both come from Indiana, shockingly, but it's not an Indiana specific law. So it applies everywhere. So at times you hear some people say this, and it's a completely valid question, that a hybrid trust or asset protection trust doesn't work. That even though they have been around for over 30 years, that they've never been pierced, that the courts can stop them, that judges can just freeze the assets before you can even trigger anything offshore. And then they cite these two Indiana investor cases. Now, the cases are real. Obviously, they're real cases. But the way they're being used and explained is very misleading. And here's what actually happened in these cases. So in Indiana Investors versus Hammond and Indiana Investors versus Victor Fink, both the trusts were fully U.S. domestic asset protection trusts when the defendants were sued. The people who did something allegedly wrong getting sued. So that's already strike one, because the trusts were fully domestic. So you had U.S. trustees subject to U.S. courts and judges, you had U.S. banks, and you had U.S. control of assets by the trustee, meaning you. And then the offshore piece of the trust, well, that portion didn't even exist yet. They didn't create it beforehand. The offshore component was just a future idea, something that would have happened later on down the line if things went bad. Well, then later on, after the lawsuit, when things actually went bad, their plan was to just trigger the trust and then transfer or literally move the assets out of the domestic trust and then into a completely separate offshore trust that was still not even created beforehand. I mean, if you're just listening to it, it sounds bad. And this is not even what we just described for a hybrid trust. It's not what these even are. So what did the courts do? They didn't pierce a trust. They didn't reach offshore assets. They didn't even invalidate foreign trust law. The courts issued restraining orders to U.S. people and to U.S. banks because those are the entities at that time that still had control over the assets. That's the key principle here. Those cases don't say hybrid or offshore trust, bad, fail, pierce them. They say this: if you wait until a threat exists, and once that threat exists, if control of the asset is still in the U.S. and it's still in your name at that time, and if it's still in your control and in your name at that time, then the U.S. courts can freeze what they or you still have jurisdiction over. And that just makes sense. So that's not a geography problem. That's a timing and control problem. They set the trust up improperly from the beginning. So why is a hybrid trust structure different when it's done correctly? Because a properly designed hybrid trust that we use, like our bridge trust, it solves that problem at inception. From the very first day that trust is created, it is a Cook Island trust. We're not creating it. We'll do it some other time later on in the future when things go bad. So from the very beginning, it's created as a Cook Island trust. The bridge trust is not a trigger trust. The assets are transferred into the trust when it's created from day one, not later on, not after the lawsuit. So we need to get the funding done right from the beginning, just like in the Solo case that we talked about. The foreign trustee is also appointed from day one. They're actually named in the trust not in a panic after the lawsuit. Courts want to see a continuous relationship with the offshore trustee that are doing their due diligence on you every year. And if duress, or meaning like a lawsuit, ever occurs, like you're getting sued and everything is set up properly, nothing is ever transferred. The trust is just one offshore trust from day one that's fully funded already, and all the assets are already owned and titled under that trust. So there's no retitling, there's no conveyance, there's no last minute move like in those cases that the courts can enjoin. Because duress in asset protection trust, specifically a hybrid trust, the duress causes a change of administration, not a change of ownership. All that's happening is that the offshore trustee who was on standby, right, just like your backup quarterback on the bench, and they're pre-named in the trust, well, they're no longer on standby. They're off the bench and playing the game now. So that's the distinction that matters, and that's the legal distinction that's being left out. You see, fraudulent transfer laws target conveyances after a claim is foreseeable. They target retitling, things like that. Changing who administers assets that's already owned by the trust and that they're already named in the trust beforehand is not a conveyance. So the real lesson of both those Indiana investor cases are that they don't defeat like hybrid trust or offshore trust. In fact, they literally don't even talk about them. They defeat delayed execution that defeat trust that say, don't worry, we'll move things later or create it later if something happens. Does that make sense?
Yeah, I mean, it's a very high level topic, and it's a lot of things that I have not really been exposed to yet. But there's a lot of people that will listen to this podcast where they are dealing with these things and they are looking for clarity on some of these topics. So I appreciate that you're able to do a deep dive and share so much of that knowledge here. Brian, how should people get in touch with you if they would want to reach out to learn more information with everything that you know about asset protection?
Yeah, just, if you're interested in a deeper dive, you can just simply click the link on my website at www.btblegal.com. And I have over 90 published legal articles on there, and I have a lot of state-specific articles as well. I use my website more as a free educational resource and educational videos, slide lectures. I have well over 70 frequently asked legal questions on there. I think it's one of the largest frequently asked question library resources and asset protection that you can get. And you can always reach out to me. I offer a 1-hour legal strategy consultation for people that come in through shows like this.
Brian, thank you so much. We appreciate you being here. And that's it. That's the pod. Thanks for watching today's episode. Make sure you check out the next one that YouTube's recommending. It's personally chosen for you based on YouTube's algorithm and AI, so hopefully it's a great fit.